Talk Shoes.
Recorded live.
Good evening, folks. TJ here. Welcome to tonight's call for the free members of urlaw.org. Just a couple of quick announcements here in a few moments, but I just want to make sure everybody's getting in, get dialed in. You can hear the audio okay. If one person can hear me fine, then all should be able to hear fine. If you can't, then the issue might be on your end. That's the only issue I've ever noticed with this kind of format. So just be sure to check your own connections and so on. So thanks everybody for being here again. This is for the premium this is for the regular members of urlaw.org. I'm not going to go through the full legal disclaimer. You all know this is not legal advice. We're just a private community having a discussion on various issues. And so I'm going to belabor the long disclaimer that's on most of our calls. I require everybody on this call, however, to read the disclaimers that are on the website at urlaw.org and abide by those, which includes remembering that this is copyrighted protected material. We're not giving legal advice. You know, we certainly invite our government friends to be here. Hopefully they're here to learn a few things, and hopefully we get it right and we can help everybody. Because our concern is every one of our fellow men that we want to help. That's our first duty under God, is to be our brother's keeper, and that's what we're here to do. So without a lot of delay, again, we have a lot of people coming in the call, so hopefully you'll all be able to catch up. We've got a lot I want to cover tonight. In fact, this is going to be a multi-part lesson that I'm going to be teaching. So before I get into the lesson plan portion of this, again, this is for our premium and free members, actually, because that's what this module is meant for, is for both. Just keep in mind, premium members will get an additional follow-up Q&A call. We're not going to do a lot of Q&A tonight because of the size of the group and the the amount of material I need to cover. Again, Q&A discussions are generally for the smaller groups that are premium membership calls hosts. So on tonight's call, we're gonna be reviewing one of my favorite books. I read a lot of books, so hopefully you are also out there reading lots of material, trying to discern what's useful and what's not. And I think one of the books I found that's, maybe 90-95% right on the button is a book called The UCC Connection, How to Free Yourself from Legal Tyranny. I'll repeat that. The UCC Connection, How to Free Yourself from Legal Tyranny. I'll even do you all a favor and put that in the chat window in case you want to go look that up over at Amazon or something like that. I definitely recommend a few books here and there that kind of give us something to follow along with, and so I'll post that in the window. Just go to Amazon, look for that. It's an inexpensive book. I think it's about $5 or $6, or you can get it over at nationallibertyalliance.org. They also provide copies of this book, and I think it really behoove you to read this because it's going to help you understand that. We're in a totally commercial world, and as far as remedies that we're going to be talking about, we're going to put our focus on what I call practical remedies that the average everyday person could actually go out there and do. There's nothing easy about walking into a courtroom, which is why we tell you to avoid it at all costs. There are many, many things you can do to avoid that, and it has to do with what your status and standing are and your basic understanding of what's really going on in the legal system. Few people really understand that when you walk into a courtroom, it's all about a trust, it's all about liens and bonds, which has nothing to do with the ticket or the tax or whatever it is they're calling you in for. No, that's not what it's for. And I think if you studied along with this book, and again, I'm going to read quite a bit out of it tonight and talk about some of it, I think you're going to find out that things aren't quite what you thought they were. If you're an advanced studier of this, some of this might sound familiar, but at least maybe you'll hear it from another point of view. If you're new to this kind of information, I think you're going to find that it's very revealing about what's going on. And if you're worried about what's happening in our world today and the politics and the Brexit and Britain and all that stuff, which is all obviously somewhat important, it's still really just barely scratching the surface of what's really happening. And I think a lot of people in this country are seriously concerned about the future of not only this country but the world and our ability to maintain our freedoms. But I'm going to tell you right off the bat, here's the bottom line. You're worried about freedom? Then it's up to you to keep it. Benjamin Franklin said, one of my favorite phrases, I've said it a lot on these calls, is they asked him when he came out of the first Congress, asked him, well, what have you given us? And I'm summarizing. He said, well, I've given you a republic if you can keep it. Now, I'm going to use words that you better understand the definition of, and if you don't know the definition, really know it, write it down, and go look it up after the call. Look up the word republic, and then look up the word democracy, and tell me if they absolutely are not the same thing. But that's all you hear on the news and on the media is about the democracy, the democracy, the democracy. Well, that has nothing to do with a system which is basic, simple rule of law. And I'm talking about basic laws, not statutes and codes. We've gotten pretty far away from that. But you know what? I'm a true believer that if you know what you're doing, you can get yourself back in line and protect yourself, because most of what's going on is not as it seems, i.e., I love to quote The Matrix and the movie The Matrix. If you haven't watched it lately, after you hear some of this, go back and watch it. Tell me if The Matrix wasn't telling you everything that we're telling you. But, of course, we're trying to give you a little more of a practical perspective on what's going on. Now, keep in mind, sometimes I get some people in this class who are part of another one of our classes, like maybe the class that Neo puts on and others. This content does not necessarily, there'll be some crossovers, but it's not part of that class. This is a separate class altogether for people that are parts of this particular group. So just keep that in mind. So a couple other things I just want to mention. We're kind of to tell you what direction we're going with this. Now, we may be covering a pretty broad picture when we go through this book, and it's a short book. All together, including references and everything else, is about 60 pages. You can sit there and read this in one night. But I want to use it somewhat as a foundation, not entirely, but somewhat as a foundation to help you understand where some real remedies might lie. The book has a lot, which we're actually going to cover. Some of the scenarios we'll only be covering on a premium member call, not this free member call, but we'll go into those scenarios as well. But I'm going to hit a lot of this, so I want you to just kind of enjoy the ride, sit back and listen. Please take good notes. Write down key words you hear that you don't fully, because believe me, there's words you think you understand that you don't, and I want to make sure that you get the most out of this. I'm sure that not everybody in the world is going to agree with everything that I say 100% of the time. And I'm sure there's many other people out there who have different philosophies on things. But I think we're all talking about the same thing, really. We're talking about the fact that there are two systems. There's a system for the U.S. citizens, which by definition, my definition, are effectively slaves, or at least they've volunteered for a benefit, which puts them under a contract and binds them to waive their rights on many things. We want to help you avoid that, because a man or a woman is not the same thing as a citizen. They're completely different words. So when we talk about these strategies here, ultimately we want to be able to use them to simply just kind of, first of all, get away from a few legal issues like a ticket or taxes, something like that. But sometimes you also have to deal with it, because in every one of these cases, and this will be in a future class, we're going to very deep detail about this, there are liens and bonds being placed against your estate, and that's how they're holding you. That lien and bond process, again, that will be really an advanced topic for the premium members, but I will get into kind of touching on that here and there as well. But therein lies also the remedy, because you can use the fact that they're creating these monetary instruments, and so you can set them off, because they only came into creation because of your signature and you're saying your name. So we're going to show you how to work around that and try to take care of those issues. Because remember, every time you go to court, there's a charge involved. A charge. Go look up the word charge and look it up in the context of the Uniform Commercial Code. And we're talking about money here. It's not just I got charged with a ticket, or I got charged with the tax thing, or I got charged with this criminal thing, or I got charged with this mortgage violation. No, the charge is a bill. So what is required to pay that bill? And it is not Federal Reserve notes. You've got to keep that in mind. All right? If you can create it with a signature, you probably can take care of it with a signature. So anyway, I just want to give you that basic premise. So let's get into this general area of study. Again, I'm not going to go into the full long announcements tonight because we have so much to cover, but I'm going to kind of read quite a bit of information from the book and then discuss some of it as we go through. It all starts off with the basic rules of the game. And again, some of this is written in the first person by a man named Howard Freeman, who gave this presentation, gosh, it's been 26 years ago. And to this day, it's still, to me, some of the most powerful information that's out there in terms of understanding what's going on. I mean, you know, we're not pretending we invented everything here. Certainly no one can make that claim. This is everything that we've been learning through this whole process of, you know, working on redemption and freedom and things like that, only comes because a lot of people have worked together and shared information. And we're going to share a lot of the information that I've kind of dissected, gone through, thrown a bunch out, brought a little bit in, and I think that just for a large audience, this is a pretty good way to look at things. So the UCC connection, how to free yourself from legal tyranny. Again, this is kind of a presentation that Howard Freeman gave years ago, but I'm just going to take parts of it and talk about it. Obviously, a lot of Americans are feeling frustrated about our judicial system, and it probably feels pretty overwhelming, often frightening. Most absolutely fear because they lack the knowledge to know what to do about it. I mean, what does fear come from? It comes from you know, something that you don't understand, and you're afraid of the outcome. So, you know, if you're really into the Bible and you understand that, fear is actually where the devil actually lives. That's how he controls you. So these people know this too. So if we want to get a path out of bondage and into liberty, and get away from what seems like tyrannical power of government agencies and the mystifying, awesome power of the courts, well, we need to put it in perspective. I think that's the key. So, you know, mostly we're usually told to go get a good lawyer, right? A good lawyer. Now, for a lot of people, you might say that's an oxymoron. That's not always true. There are some good ones, but fundamentally they're part of a system that is dark by its very nature. So, because he is actually an officer of the court. He's there to negotiate a deal, not to gain your freedom, in my opinion, for the most part. So you need to have a basic understanding of the rules of the game. You're going into a game, your ball game. You need to understand that these people have a monopoly over the knowledge of this game, and but we need to bring that to an end, because it says in the Bible we perish for a lack of knowledge. Well, let's stop lacking knowledge. Okay, look this stuff up. It's not very hard to actually learn. So the average person can actually learn this, but you're not going to learn it in school. You're not going to learn it by hiring a lawyer. You're going to learn it by implementing your own rights. Like Benjamin Franklin said, you gain your freedom, you know, if you use it. That's kind of what he said. I gave you a republic if you can keep it. Now, remember this, that lawyers understand procedures. They're masters of procedure. Now, you and I typically aren't taught procedure, so we get confused and go, oh my gosh, there's all these procedures. But if you actually went through the rules of procedure and kind of did a summary view of those things, you'd find that it's actually quite manageable. An average person can learn it. I got a lot of my information on the Federal Rules of Civil Procedure. They have these little 4-page laminated cards that are out there, and it has a really good summary of this. And let's see, the website for that is quickstudy.com, quickstudy.com, and you can get a little 4-page summary of the civil procedure, and it's really easy to kind of pick up and learn. You shouldn't be intimidated by this stuff. You think, well, now why do I need a lawyer? What do I need about law? Can't I just hire a lawyer? I can assure you that will be the way to get yourself in the most trouble, because it brings you into the system. But yeah, it's good to have them around to talk to about procedure. I've advised people to call a lawyer and ask them about a procedure, or even ask the court about a procedure, because you need to know the rules of the game if you're going to play. So let's see. Let's go. I'm just jumping ahead here. So we must take the responsibility for finding and putting to good use the truth. It is we who must claim and defend our God-given rights and our freedom from those who would take it from us. It is we who must protect ourselves, our families, and our posterity from the inevitable intrusion into our lives by those who live parasitically off the labor, skill, and talents of others. Boy, is that absolutely the truth. Again, think about the movie The Matrix. What was that about? It was about the machine living off you, providing its labor and energy. And actually, labor is a very important word, because we'll get into that into the advanced studies about how actually it's even a calculated figure that they put in place upon you when they put a lien or bond on you in court. They're calculating the value of your labor. It's just a way to monetize your slavery. So we're looking for a peaceful method of dealing with this, and that is really what this is about. We're not here to fight, because it's not necessary to fight if you have knowledge. Okay? We perish for a lack of knowledge, not for our inability to fight. All right? So let's use a little wisdom, and let's get into understanding. And then the greater knowledge will give you hope. And with God's help, we will be able to live in peace and freedom and right here on earth. I think we can do it. At least do a better job of it. Okay? It really is up to us. Now, those of you who are not Christians and you don't believe that sort of thing, I respect that. Everybody's entitled to their perspective. But I happen to know, and I know it's an inevitable thing to talk. It's inevitable that you cannot talk about the Bible when you talk about law and what actually works, because it is only from that authority that we get anything. We get anything from the Constitution. The Constitution just puts limits on government, so they have to protect those rights. It doesn't give you any rights. And people make these arguments all the time. I want my constitutional rights. There is no such thing, guys. Your God-given rights are there, and you are an heir to a kingdom. It's right out of Romans. It talks about this. You're the co-heir with Christ. And if you don't want to accept that position and the rights that come with that, well, I'm sorry. Try it on your own and see how it's working out. So, that's why I accept it. And that's how I see it. It says in Matthew 10:16, I send you forth as sheep in the midst of wolves. Be ye therefore wise as serpents and harmless as doves. See, we got to be smart, folks. Use our mind, use our brain, and let's get this right. This is where you're going to win. So let's get into this. So introduction. This is how he beat, it's in his first word phrasing, I beat the IRS. A lot of people might want to hear about that, right? So I used Supreme Court decisions. I tried to use in these courts, and if I hadn't, I would have been convicted. I was involved with the Patriot Group, boy oh boy, and I studied Supreme Court cases. I concluded that the Supreme Court had declared that I was not a person required to file an income tax, that tax was an excise tax on privileges. I hope you're writing these words down. Person, excise tax, privileges. Make careful note of those words, all right? So I quit filing and paying income taxes, and it was not long before they came down on me with a heavy hand. They issued a notice of deficiency. There might probably be people on this call that have had those, all right, which had a huge sum on it, okay? And he asked, where in the world did you get that figure, $60,000? So, but even if he had been paying taxes, he never had so much money in the world anyway. So how could I have owed that much? I mean, what did they give you that you owed them for? That's what you have to ask. Where's the contract? Section 1. So let's talk about this. Never argue the amount of a deficiency or a case like because I get people all the time coming to me with a credit card case, and they'll say, well, I just started talking about that I didn't owe this, and I owe that, and all this stuff. Well, that's all confession. When you agree to any of it, you've agreed there is a contract. So stop doing that. Don't argue the amount of the deficiency. Never argue the facts in any case, especially a tax case. Because once you enter into arguing about the facts, you're acknowledging and giving jurisdiction that you are, in fact, a taxpayer owing something. You got off the subject. So never argue the amount, all right, or how much you owe. The question is are you required to file? Where does it say in the code that you, the man or woman, not the person or the taxpayer, is required to file? Key words to ask, because they'll throw these words around on you, and believe me, they're not there to help you. So anyway, he got aggressive. He went to the problem resolution officer, the district director, and so on. And by the time he got into that district director's office, they started calling ahead, because most people aren't willing to go up and stand up for their rights and ask questions. Boy, let me tell you what, asking questions is the key to success in all this. You forget one thing about anything we talk about tonight. It's the one who's asking questions is in control. So I went down the elevator to the guy's office. They kind of dodged him for a little bit, but the guy dodged him, didn't want to let him in. He finally kind of weaseled his way in and stood by the door and finally got in. I mean, they literally wanted to avoid him at this point because they aren't used to people standing up for their rights and actually asking the questions about truth. Anyway, the story goes on, and I'm really paraphrasing here. They offered him a coffee and cookie and asked, "What do you want to talk about?" And he'd explained the situation that he's been receiving letters and wonders what this is all about. And asked this guy if he knew what mail goes out of this office. And the director said, "Well, I couldn't read everything, but my bag is full." So I said, "Here are some of the agent's writings, letters that contradict decisions of the Supreme Court of the United States." And they're not doing it in their name. They're doing it in your name. They're using your name, Mr. Boss. And he was very interested to hear about this. You think these people actually know what the left hand and the right hand are doing sometimes? I wonder. So anyway, he asked if I could leave the information with him, which I did. And he said he'd contact me in 3 days. And then 3 days later, he did contact. And then he just simply said, "Mr. Freeman, just to let you know that we will be glad to let you know that your notice of deficiency has been withdrawn. We've determined that you're not a person required to file." You see, we talk about the living man and the fictional person and all that. I think the real trick to all this is, guys, this is just my observation over the years of studying this, is a man shows up in person when he has to and presents himself as a man, which is what he did. Instead of just doing it in paper and writings. I know everybody would just love to hide behind a piece of paper and a computer keyboard. The reality is when he walked in, he found that that's really what got the result. And this is a true story. Last week I spoke to another gentleman who's been doing some filings, and they were actually asking similar questions and sort of challenging the returns and so forth. And it wasn't until he got on the phone for about 2 hours, hammering through different people, getting up the line, that he got a tax lien released. You see, if he had never got on the phone and showed up as the living man, you got to show up. You want to prove you're a living man? You put it on a piece of paper, do you show up? Which is it going to be? No, I don't mean in court. I'm talking about in the administrative side of things. Do it before you have to go to court. And court's the last place you want to show up. But, you could start with your writings. It's very important. But I think there's something really key about the speaking man to man to get things done. And if you know where you stand and if you know what those writings say. So there's some more. You got to go into a case where a guy did screw this up and had to do with him hiring an attorney and so forth, and making arguments. So I'm not going to get into all that. Let's talk a little bit about in Section 3. It talks about public law versus private policy. By the way, before I go on, any of you wonder what does this have to do with mortgages and debts, and what does it have to do with taxes or any legal issue I'm saying? These are foundations you need to know. If you don't know this basic information, I assure you, you're never going to have success at those things. So this is why we're focusing on this right now. So Section 3, public law versus public policy. Name any decision of the Supreme Court after 1938, and I'll honor it, but all the decisions you read were prior to 1938. He went on prior to 1938, the Supreme Court was dealing with public law. Public law. Since 1938, the Supreme Court has dealt with public policy. Now, do you think the word law and policy are the same thing? So the charge that Mr. S has been being tried for public policy statute and not public law, and those Supreme Court cases do not apply to public policy. So what happened in 1938? Well, this is an important thing where a lot of people get screwed up. So he said at that point, I've already told you too much. I'm not going to tell you. Well, Section 4 talks about 1938, the Erie Railroad case. I began to investigate. I found that 1938 was the year of the Erie Railroad versus Tompkins case of the Supreme Court. It was also the year they claimed they blended law with equity. Very important event. So, at least they claim they did. Okay, that doesn't, Anyway, I read the Erie Railroad case. A man sued the Erie Railroad for damages, and he he was struck by a board sticking out of a boxcar as he walked along beside the tracks. The district court decided that in commercial law, that's negotiable instrument law, and by the way, that's what has to do with the UCC, Uniform Commercial Code, this man was not under any contract with Erie Railroad, and therefore he lacks standing to sue the company. By the way, that works both ways. So under common law, which is natural law, don't confuse it with the Old English common law, we're not talking about that, we're talking about just simple natural law, he was damaged, and he had the right to sue. So which type of law is he going to go under, right? So this overturned a decision of over 100 years. The Swift versus Tyson case in 1840 was a similar case, and the decision of the Supreme Court was that in a case of this type, the court would judge by common law, which is natural law, which has to do with do no harm. If that's how complicated the law is. If there's nobody harmed, there's no case. In a state where the case occurred, in Pennsylvania. In the Erie Railroad case, the Supreme Court now ruled that all federal cases will be judged under negotiable instruments law. Wow. So they pulled it out of common law, and now you're in negotiable instruments law. This is everything that's going on in the court right now. Again, we'll get into deep detail how they're creating monetary instruments, bonding you, and it's all about making money with negotiable instruments. And you're in there arguing rights and facts, which are irrelevant. So that's what they did. That's how they blended law with equity. And in their court system that you go into, this is why you've got to be careful going in there. I assure you, if you go in there with a lawyer or you go in there to argue to try to win on the facts, you literally have a less than 2% chance if they're coming after you for something. This is as a defendant of winning. Now, as a plaintiff, it's a little different, but as a defendant, be careful. So, there's still pieces missing here. If you want to cover this section, well, fortunately, I made a friend with a judge. Now, you won't make friends with a judge if you go to court like a wolf in black sheep country, but you must approach him as though you are the sheep and he is the wolf. And believe me, that is exactly what's going on. If you go to court as a wolf, if you make demands and tell the judge what the law is, how he had better uphold the law or else, remember the verse, I send you forth as sheep in the midst of wolves? Be ye therefore wise as serpents and harmless as doves? We have to go into court and be wise and harmless and not make demands. We must be humble and play a little dumb sometimes, kind of like you'd be the good old boy. But ask questions, kind of like, Columbo. He goes, Mrs. Johnson, let me ask you just one more question. I mean, that's actually like a personality you should adopt if you have to go to court and be asking a lot of questions. And what you can do is box the judge into a corner and get them to admit what they don't want to admit, that this is not truly a court of law. It's all about money. So the author basically won a lot of courses based upon taking that approach. And then Section 6, America is bankrupt. This is something a lot of people have no clue about. If you're all running around worried about buying gold and the monetary system collapsing and Brexit and Britain and the election and all that fluff, and you're worried about, oh my gosh, America's going to go bankrupt. Ladies and gentlemen, it's been bankrupt a long time. A lot of you know this, a lot of you might not. So anyway, he goes on, later on he visited the judge and told him my problem with the Supreme Court cases dealing with public policy rather than public law. And he said in 1938, all the higher judges, the top attorneys, and the U.S. attorneys were called into a secret meeting, and this is what they were told. America is bankrupt. It's a bankrupt nation. It's owned completely by its creditors. Now, if you've ever been in through a bankruptcy or known somebody that has been through a bankruptcy, that's what happens. The creditors take over everything, and they control you and own you. Well, that's what happened in 1933, essentially, when we were at the height of the Depression. We were bankrupt, and we had to have the bankers come in and create a new system, and they gave it a really cool name called the New Deal. So these creditors, they own Congress, and they own the executive branch, and they own the judiciary, and they own all the state governments. That's why everybody reincorporated at that point. When you go bankrupt, you reincorporate. They created new names, similar sounding names, But basically, everybody took silent judicial notice and never openly really discussed it. It just happened. So now courts operate under Admiralty jurisdiction. It's really about claims now, so it's merely about who's making the claim. And you can use that to your advantage. Don't run from that necessarily. But they don't necessarily want to call it Admiralty. In fact, if you ask them if it's Admiralty, they won't want to discuss that. In other words, it's all about making money and claims. It's not really about rights and constitutions anymore. So let's talk about Admiralty courts. The reason they cannot call it Admiralty jurisdiction is that your defense would be quite different in an Admiralty jurisdiction from your defense in a common law. In Admiralty, no court has jurisdiction unless there is a valid international contract in dispute. Well, how do you go to court and how do they get jurisdiction over you might say? Well, when you know it is Admiralty jurisdiction and they have admitted on the record that you are in Admiralty court, you can demand the international maritime contract to which you are supposedly a party to and which you supposedly have breached to be placed into evidence. But no court has Admiralty and maritime jurisdiction unless, here it is, there is a valid international maritime contract that has been breached. Now, I assure you, every time you go into court, you never brought this up. So you just say innocently like a lamb, well, I never knew I got involved in an international maritime contract, so I deny that such a contract exists. If this court is taking jurisdiction in Admiralty, then place the contract into evidence so I might challenge the validity of the contract. What they would have to do is place the national debt into evidence. And they would have to admit that the international bankers own the whole nation and that we are the bankers' slaves, or so they presume. So, Section 8, not expedient. But the banker said it's not expedient at this time to admit that they own everything and could foreclose on every nation in the world. The key behind the buildup of the United Nations is a military force. The key to disarming America is the key they're really after, because we are, as a country, a military force. Everyone's armed. So this is the key to ending the Cold War, as was the key. Like now, we have no more enemy. We can melt all our guns, right? No, wrong. The banks plan to foreclose at some point, or slowly, or in some controlled fashion. But they don't want their heads blown off while they do it, so they simply dictate to Congress to try to do things to get rid of guns and rights and common sense. They infuse confusion. You know, there's like somehow there's more than two actual sexes in the world. I mean, come on, common sense here, folks. You know, simple things like that. That an armed group is the last place a terrorist is going to go. It's the safest place on the planet to be. But see, they make everything backwards. They speak everything in reverse terms. So that's the reason they haven't been able to do what they wanted to do. So they might be working, some say they're working towards a world army and all this stuff. Hopefully we're beginning to see that breakdown with the Brexit. That's actually what's good news about that, is the movement away from centralized military rule of the world. Believe me, there's a war going on, and it's the people against the governments, unfortunately, and it shouldn't be that way. The governments belong to us. We are the creators of the entire thing. It doesn't exist without us, or what would be the point of it? So, you know, that's kind of the thing we have to start looking at. And our opportunity to deal with the legal system is the place to prove our ground. We all have to step up. All right? So let's talk about jurisdiction, Section 9. The Constitution of the United States mentions 3 areas of jurisdiction which the courts may operate. Okay, this is key. You're not going to know, you have to know these 3 things are going on. 1, common law. Common law is the natural or constitutional laws based upon our Creator's laws as originally presented by Moses. Anytime someone is charged under the common law, there must be a damaged party, and that's what you've got to demand. You're free under the common law to do anything you please as long as you don't infringe on the life, liberty, or property of someone else. You have a right to make a fool of yourself if you want, provided you do not infringe on the life, liberty, or property of someone else. Common law is very simple and fair. Common law does not allow for any government action which prevents a man from making a fool of himself. I've done that myself. Anyway, for instance, when you cross the state line, you will probably see a sign which says, "Buckle your seatbelts, it's the law." This cannot be common law because who would you injure if you don't buckle up? Nobody. This would be compelling performance, but common law cannot compel performance. Any violation of common law is a criminal act that is punishable. And you say, well, how come they're not doing it? Because there's also a couple other types of law that they slip into. Section 2 is equity law. So the first one is common law, next one is equity law. Which equity law is law which compels performance. It compels you to perform the exact letter of any contract that you are under. If you have compelled performance, there must be a contract somewhere, and you are being compelled to perform under the obligation of that contract. Now, this can only be a civil action, not criminal. So in equity jurisdiction, you cannot be tried criminally, but you can be compelled to perform to the letter of the contract. If you then refuse to perform as directed by the court, you can be charged with contempt of court. And this is a criminal action. Are our seatbelt laws equity laws? No, they are not, because you cannot penalize or punish under equity jurisdiction for not keeping to the letter of a contract. This has, of course, changed since the publishing of this article, so read on. Let's talk about Section 12, Admiralty and Maritime Law. All right? And this is where we get into really the keys to some of these things. Admiralty is a civil jurisdiction of a compelled performance which has criminal penalties for not adhering to the letters of a contract, but it only applies to international contracts. International contracts. Now we see what jurisdiction the seatbelt laws are, and all the traffic laws, building codes, ordinances, tax codes, etc. are really under. Whenever there's a penalty for failure to perform, such as willful failure to file a return, that's Admiralty and Maritime Law, and there must be a valid international contract in force. And I bet you never even thought about that issue. You were just worried about how much you owed, right? However, the courts don't want to admit that they operate under Admiralty and Maritime jurisdiction. So they took the international law or law merchant and adopted into their codes. Uniform Commercial Code. This is what the Supreme Court decided in the Erie Railroad case, that the decisions would be based on commercial law or business law, and that there will be criminal penalties associated with it. So essentially, turned being into debt possibly a crime. Again, that's way out of line with our Constitution, right? But we do it because we're in this bankrupt state. They can do all kinds of things. So since judges are instructed not to call it Admiralty and Maritime jurisdiction, they call it statutory jurisdiction. So from now on, whenever you hear the word statutory, I want you to think of Admiralty and Maritime and bring it up, because they don't want to talk about that. So if you look for the word statutory jurisdiction in the 4th edition of Black's Law Dictionary, it's not there. So look up the word statute, and under its definition in this paragraph. This word is used to designate the written law in contradiction to the unwritten law. So unwritten law is common law. I'm sorry, I'm using the wrong word. Contradistinction means as opposed to. All right. So we're really talking about courts of contract here, aren't we? But where's the contract? And what are the elements of a contract that have to be in place? So you may ask how you got into the situation where we can be charged with failure to wear seatbelts or be fined for it. Isn't the judge sworn to uphold the Constitution? Well, yes, but you must understand that Article 1, Section 10 of the Constitution gives us unlimited right to contract, as long as we do not infringe on the life, liberty, and prosperity and property of someone else. So you see, that's where they're getting you guys. Contracts are enforceable, and the Constitution gives 2 jurisdictions where contracts can be enforced, equity or admiralty. But we find them being enforced in statutory jurisdiction. And what I said earlier about statutory, that's admiralty. Now this is an embarrassing part that the courts should admit when you bring it up. You can box the judges into a corner by asking them some questions. We'll get into these questions later, by the way. We won't do it all on this call tonight, but you'll find you can really hit some pretty hard questions on these folks and really box them in. Remember, he's who's asking the questions in control. So Section 14, contracts must be voluntary. See, they can. I have here all the time people say, they forced me to do this and they forced me to do that. And if I really, whenever I ask the questions and I ask a few more questions, I thought they weren't forced to do anything. They were asked. Roll down your window, please. Driver's license and registration, please. Contracts must be voluntary. Under the common law, both parties must enter into every contract, write this down, knowingly, voluntarily, and intentionally, or the contract is unenforceable and void. These are characteristics of a common law contract. Do you have a contract with that guy pulling you over on the road? Where is it? Let me see it in writing. Where's my signature? Where's the consideration? There is another characteristic. The contract must be based on substance. For example, contracts used to read, for $1 and other valuable consideration, I will paint your house. That was a valid contract, and the dollar was a genuine silver dollar. It had substance money, not debt, which is what we're using now, debt instruments. Now you suppose you wrote a contract that said for 1 Federal Reserve notes and other considerations, I will paint your house. And suppose, for example, I painted your house the wrong color. You could technically go into a common law court and get justice. Well, no, you couldn't. Since there's no substance, the Federal Reserve note is a debt, there is no contract. So in reality, whenever Federal Reserve notes are being used, you really can't have a contract. So how could they ever present you a contract? So you see the Federal Reserve note is a colorable dollar. Colorable. Look up the word colorable. As it has no substance. And the common law jurisdiction that contracts would be, that contract would be unenforceable. So they have to be dealing with colorable admiralty courts, don't they? So it's colorable means that which is in appearance only and not what it purports to be. Hence, counterfeit, feigned, and having the appearance of truth. It's like the Wizard of Oz. Section 15, colorable money and colorable courts. The word colorable means something that appears to be genuine but is not. Does it look like you go into court when you went to court? Does it look like there's a judge up there? Maybe it looks like $1 or maybe it spends like $1, but if it's not redeemable for lawful money, that is silver or gold, it is colorable, fiat, fake, false. If the Federal Reserve note is used in contract, then the contract becomes a colorable contract, and colorable contracts can only be forced under colorable jurisdiction. You see how they're pulling you in there? So by creating Federal Reserve notes, the government had to create a colorable jurisdiction to cover the kinds of contracts that use them. We now have what is called statutory jurisdiction, which is really not a genuine admiralty jurisdiction. Judges are enforcing a colorable admiralty jurisdiction because we are using colorable money. It's all in the Wizard of Oz land, folks. Kick your heels together 3 times and get out of there. Colorable admiralty is known as statutory jurisdiction. Remember, they always cite statutes and codes to you, but that's not even evidence that applies to you. How come you're not bringing that up? What does it have to do with me? So Section 16, the Uniform Commercial Code. This is where it starts to happen. By the way, again, having this understanding is going to be critical to understanding the remedies we're going to talk about down the road here real soon. So I want you to have this foundation. If you've got to listen to this a couple of times and read this book a couple of times, it will really help you understand how to really fix all these problems, because we can come into these places and actually take care of our business and get out of there. So Section 16, the Uniform Commercial Code. The government established a colorable law system to fit their colorable currency. It used to be called the law merchant or the law of redeemable instruments because it dealt with paper, which was redeemable in something of substance. But once Federal Reserve notes had been declared unredeemable, there had to be a system of law which was completely colorable from start to finish. So the system of law is codified in the Uniform Commercial Code, which has been adopted in every state of the Union. Every state, even California, folks. Everybody always tells me California is different. Actually, they're all the same. They're all under one corporation. This is colorable law used in all courts of the nation. I explained one of the earlier keys, which is the country is bankrupt and we have no rights. If the master says jump, the slave better jump. Better, in fact, say how high, because the master has the right to cut off his head. As slaves have no rights. So when they bring you to court, you wonder why they treat you like you have no rights, because you don't know what kind of court you're in. See, the creditor masters had to cover up these facts, so they created a system of laws called the UCC, which is colorable jurisdiction under the UCC, and that is the key to understanding what's happening. Now, if you learn how to work that a little bit, you can work it to your advantage. Section 17, contract or agreement. One difference between common law and the UCC is that in common law, contracts must be entered into, 1, you better know these, knowingly, 2, voluntarily, 3, intentionally. You get pulled over on the side of the road, show me the contract. All right? Even a tax form, was that a contract? Was it under duress? Probably. So under the UCC, this is not so. First of all, contracts are necessary, but under the UCC, agreements, not contracts, can be binding on you. And if you only exercise the benefit of an agreement, you exercise the benefit of the agreement, it is presumed or implied that you intend to meet the obligations associated with those benefits. Any of you out there getting a benefit? Did you know going to court is a benefit? Driver's license, marriage license, public school, birth certificate for your kids, all are benefits. So if you accept a benefit offered by the government, you are obligated, or at least presumed to be obligated, to follow every statute involved or associated with that benefit. So congratulations. You got a health insurance policy mandated by the government. Now you're subject to 28,000 pages of regulations. And I got my policy, though. So you see, this is what we're doing to ourselves, folks. We're getting into agreements, not contracts. And that we're accepting a benefit, which implies an agreement. So their method, what they're trying to do is get everybody exercising a benefit, and they keep offering you more benefits. Now they're talking about free education and loan forgiveness and everything that they put their hand to. They're just a corporation handing you a benefit, and they want something in return, folks. Nothing's for free. So they want to get everybody exercising a benefit, so they don't have to tell the people what the benefit is. It's so vague anywhere, most people don't even know it, between marriage license, marriage certificates, birth certificates. So, by the way, all of these things can be replaced with something else. Did you know that? Well, what if you kept all your money? Could you have a nice retirement? What if you drove down the street without a license? Could you actually get from point A to point B without it? What if you got married and just put it into a Bible? That actually has equal standing under the Federal Rules of Procedure as a marriage license. But now they can't interfere with your marriage and your kids. Why do we keep volunteering for this stuff? What are we really getting? So, Section 18 talks about the compelled benefit. Compelled benefit. I believe the benefit being used is that which we've been given the privilege of discharging a debt with limited liability instead of paying a debt with substance. Now this is where it gets real interesting. They had to give us things in return for getting us into these compelled agreements. So we talk about HJR 192, you might have heard of that, but nobody knows how to actually get it exercised. Well, that's because they don't really understand how the system works. You just can't write something on a piece of paper and expect magic to happen. You got to know what you're doing. And so our goal in the premium training is going to show you how to do some of that. But you can't really pay off a debt because you only have debt to pay it with. That doesn't make sense. So when we pay a debt, we give substance for substance, something of equal value. If I created a note that created a debt and they never really loaned me any money, why couldn't I create another note to replace the debt? Wouldn't that be a discharge or a set off? Think about that. And we're going to show you how to apply that. So if I buy a quart of milk with a silver dollar and the dollar paid for the milk, but the milk paid for the dollar, substance for substance, pound for pound. That's something of equal exchange for value. Did you know when to give your labor for value instead of income? That's just an exchange. So if I use Federal Reserve notes to buy the milk and I have not paid for technically, there is no substance in the Federal Reserve notes. It's worthless paper given in exchange for something of substantive value. So I'm just creating debt. Congress offers us this remedy in the form of a benefit. Debt money, fake money, authorized by the Federal United States Corporation and which can be spent over the continental United States area, and is declared legal tender for all debts, public, private, and so forth. And the limited liability that you cannot be sued for not paying your debts when you discharge the charge using this callable money. So in other words, if you've used it, at least you've released yourself from some liability. So they said, we're going to help you out. You can discharge your debts instead of paying your debts. When we use this callable money to discharge our debts, we cannot use common law courts. We can only use colorable law courts. We're under the jurisdiction of the UCC, and that's their arena. So we're using non-redeemable negotiable instruments, and we are discharging debt rather than paying debts. So you see, you do have the ability to discharge the debt, but it's not truly paying it. So let's talk a little bit about remedy and recourse, and then we'll talk about some this in the next call. We'll go into some more depth on this. Every system of civilized law must have two characteristics, remedy and recourse. By the way, if you have questions, you're in the chat room, you could chat those in, although we're not going to go into great depth. We're just covering the basic material tonight. Section 19, remedy and recourse. Every system of civilized law must have two characteristics, remedy and recourse. Remedy is the way to get out from under the law. Recourse is if you had been damaged under the law and you can recover your loss. So you lose an arm, it's kind of hard to recover an arm. The common law and the law of merchants and even the UCC all have remedy and recourse. So they all have, these are all systems of fairness to some degree. But for the longest time, we couldn't find it. So if you go to a library and ask to see the UCC, the Uniform Commercial Code, they will show you a shelf of books completely filled with the UCC. You can also go to cornelllaw.org, I think, and just to look up Cornell Law, search for lots of UCC documents there as well. I suggest knowing that and learning where to look those things up. When you pick up one volume and start to read it, you'll seem to like it's intentionally been written to be confusing, kind of like the IRS code. It's called a code for a reason, right? So it took a long time to discover where the remedy and recourses are found in the UCC. But we found it right there in the first volume. And it's UCC 1-207 and 1-103. And also you'll want to make a note that 207 has been replaced with 308. So when you hear we talk about UCC 1-207 or 1-103, write those down, go look them up, UCC 1-207 and UCC 1-103. Read those carefully and get to know those. They're going to really help you. And again, 1-308 has also sort of been replaced. So the remedy, here's one form of remedy. When you sign something, especially a government document or a banking document or some sort of contractual agreement, remember these things, okay? They may not be used in your everyday, person-to-person things, but when you're dealing with entities in the system, you need to know this stuff. So, you want to make a valid reservation of rights, which preserves whatever rights the person possessed at that time, preventing the loss of such rights by application of the concepts or waiver or estoppel. That's UCC 1-207. It's important to remember that when we go to court that we are in a commercial international jurisdiction. You're not in a court of law, so stop calling it that. If we go into court and say, I demand my constitutional rights, the judge will most likely say, and many people have heard this who've been on this call, you mention the Constitution again and I'll find you in contempt of court. Boy, how many times have I heard people told that? Well, we don't then understand how we can do that. Hasn't he sworn to uphold the Constitution? The rule here is this. You cannot be charged, by the way, look up the word charged, under one jurisdiction and defend under another. So if one issue is about a charge, you should be dealing with the charge. If one's about a crime, you should be dealing with the crime. But they always charge you. So, for example, if the French government came to you and asked where you filed your French income tax for a certain year, do you go to the French government and say, I demand my constitutional rights? No. The proper answer is the law doesn't apply to me. I'm not a Frenchman. Are you a U.S. citizen? Really? You must make your reservation of rights under the jurisdiction in which you are charged, not under some other jurisdiction. This is a big mistake people make. So in UCC court, you must claim your reservation of rights under the UCC 1-207, which is now 1-308. So at this point, it appears 1-308 is the current one to use. So write that down. Reserve your rights under UCC 1-308. Section 21. UCC 1-308 goes on to say, when a waivable right or claim is involved, the failure to make a reservation causes the loss of the right and bars its assertion at a later date. I gave you a republic if you can keep it. I'm telling you, this converts to what they were telling us at the beginning. This is going to happen. So let me read that again. When a waivable right or claim is involved, by the way, when you go into a U.S. jurisdiction court and you say I'm a U.S. citizen or I live at a certain address or if I have a driver's license, all those things identify someone who is a U.S. citizen. But if you reserve your rights to be a man or woman, that's what you want to be labeled as, not a citizen. Because a citizen, they have rights to. So failure to make a reservation causes a loss of right and bars its assertion later. That's 1-308.9. Go look it up. You have to make your claim known early. And frankly, what we found is you need to make it on an ongoing basis. You have to keep reminding them, even if they stop and come back and recess. That's a trick to try to get you to re-waive your rights. So just remember that. You have to make your claim known early. Further, it says the sufficiency of the reservation, any expression indicating an intention to reserve rights is sufficient, such as without prejudice. That's another version of saying UCC 1-308, just write without prejudice. Whenever you sign a legal paper that deals with the Federal Reserve notes in any way under your signature, write without prejudice or without prejudice UCC 1-308. This reserves your rights. You can see that at 1-308.4 that you have sufficiently reserved your rights. Don't believe me? Go look this stuff up, guys. That's how you stop letting them grab you and pull you into their jurisdiction and confuse you. It's very important to understand just what this means. For example, one man who used this in regard to a traffic ticket was asked by the judge what he meant by writing without prejudice. Now, by the way, when they're asking you questions about those kind of issues, it's a setup. Okay? So without prejudice, and he wrote a statement in the court. He had not tried to understand the concept. He didn't understand what he was writing. So this is why I say be careful. If you're going to use this stuff, make sure you look things up. He only wanted to use it to get out of paying the ticket. He did not know what it meant. When the judge asked him what he meant by signing that way, he told the judge that he is not prejudiced against anyone. Sorry. The judge knew that the man had no idea what he meant, so he lost the case. You must know what it means. This is what I was talking about earlier. You can write all the greatest documents in the world, which you should, but you better know what every word of them mean, and you better be able to back it up. And by the way, it's not your duty to answer questions. It's your duty to ask questions. I would have said, don't you know what without prejudice means? I assume that you're a person of the law. You understand it, right? And put the burden of proof back on him. Don't let him put it on you. Always be the one asking questions. So, Section 22, without prejudice, UCC 1-308. When you use without prejudice or without prejudice 1-308, in connection with your signature, you're saying, I reserve my right not to be compelled to perform under any contract or commercial agreement I do not enter into knowingly, voluntarily, and intentionally. I do not accept the liability of any compelled benefit or any unrevealed contract or commercial agreement. Now, you'd have to almost memorize this to really abide that. Get it into your head. This is what you're doing. And you have to stay on it because they will try to get you off on another subject if you use this. So be ready for that. So what is the compelled performance of an unrevealed commercial agreement? Well, when you use Federal Reserve notes instead of silver dollars, it's voluntary, right? No? No, it's not. There is no lawful money, so you have to use Federal Reserve notes. They don't give you a choice. It's compelled. You have to accept the benefit. So the government has given you a benefit to discharge your debts. How nice, aren't they? But if you have not reserved your rights under 1-308, you are compelled to accept the benefit. In other words, you can't shake that thing off. And therefore obligated to obey every statute, ordinance, and regulation of the government at all levels of government, federal, local, and state. So if you understand this, you'll be able to explain it to the judge when he asks. And he will ask. So be prepared to explain this statement in court. You'll need to understand UCC 1-103. UCC 1-103, argument and recourse. See, they're playing UCC on you guys. It's not court. But they know it's all about every word that comes out of each other's mouth is forming agreements. So if you want to understand this fully, go to the Law Library and photocopy those two sections from the UCC we've mentioned. And it's important to get the Anderson version. Some of the law libraries only have West Publishing version, which is difficult to understand. Frankly, you can go online and pull the ones that are on there now. This was out way before the online versions were available, and they're sufficient to get the basic language. But remember, when you read the language of these things, think about it as they're talking about you, not banks, because you are in a banking system. Get it? You're generating these notes, these agreements. It's about you. Why would all this exist if it wasn't about us? Think about that. Okay. We got one more section, and then we'll call it a night. We're going to talk about recourse. Recourse appears in UCC 1-103.6, which says the code is complementary to the common law, which remains in force, except where displaced by the code. So that's kind of confusing. The statute should be construed in harmony with the common law, unless there is clear legislative intent to abrogate the common law, and that's UCC 1-103.6. This is the argument to use in court. The code recognizes common law. If it did not recognize the common law, the government would have to admit the United States is bankrupt and completely owned by its creditors. They do not want to admit that. They'll say you're a crazy sovereign when you bring it up. So what? It's a fact. So it's not expedient to admit this. They don't want to admit that publicly. The code is not written to entirely override the common law. It never was. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights pursuant to UCC 1-308, you can insist that the statutes be construed in harmony with common law. And you have to stay on that dog bone and stay with it. They will try to get you off. They're going to call you names. They're going to divert you. Sorry, it's a big theater. It's a play. It's a show. Stay on your position. Sorry, I haven't waived my rights. You got any proof? You've got proof of the contrary? I have. Otherwise, this is over. That's what you got to be saying. Then don't wait for the judge to give you a decision. You make the decision. So if the charge is a traffic ticket, for example, you may demand that the court produce the injured person who has filed a verified complaint. Produce the injured person who has filed a verified complaint. For example, if you are charged with failure to buckle your seatbelt, you may ask the court, excuse me, but who was injured as a result of the failure to buckle up? However, the judge won't listen to you. He just moves ahead with the case, which, they commonly will do. You can expect these moves. You'll want to read in the last sentence of UCC 1-103.6, which states the code cannot be read to preclude a common law action. And I would say probably you want to put that in a question. Hey, Your Honor, doesn't it say at 1.103.6 that the code cannot be read to preclude a common law action? I always like putting things in the form of a question. So tell the judge, Your Honor, I can sue you under common law for violating my rights under the UCC, can't I? I have a remedy, don't I, under the UCC to reserve my rights under common law. I always put a question mark at the end of these sentences if you're not sure what to say. I've exercised my remedy, so you must construe this statute in harmony with the common law. Don't you have to do that? To be in harmony with the common law, you must bring forth the damaged party. Isn't that true? I mean, I would always throw a question in at the end of a statement like that. It's a much safer way to finish your statements. Because I found a lot of people going to court and make statements. There's really no hooking them, and so the question hooks them. So no, actually it's better to use a rubber stamp because this demonstrates that you had previously reserved your rights. Simple fact, it takes several days or a week to order and get a stamp, so it shows you reserved your rights prior to signing the document. So that just shows you've reserved your rights before. You got to start early in these processes. That's what it's getting at here. Every document, every you receive, start reserving your rights on it. So if the judge insists on proceeding with the case, acts confused, and asks the question, let me see if I understand, Your Honor, you could say, has this court made a legal determination that the sections of 1-308 and 1-103 of the UCC, which is the system of law you are operating under, not me, you, are you saying those are not valid law before this court? Now, they can't say no to that. So if the judge you really got him in a jam now. How can the court throw out one part of the code and uphold another? If the answer is yes, then you say, put this court on notice that I'm appealing your legal determination. Of course, the higher court will uphold the code on appeal. You hope you never have to get there. The idea is to stop it before you ever get into court. That is the key to some of the things we're going to be talking about, is how to stay out of court. But if you get into court, these are just a few little tips you need to know, and have your paperwork done in advance and stand on what it says. So we'll get into the next call. We'll get into the practical applications of traffic court and a few other scenarios where we'll actually go through an actual sort of a Q&A scenario, how it might be used in an IRS matter, a bankruptcy matter, or some other government issue like FEMA or something like that. We'll compare it to the Constitution. We'll talk a little bit about the U.S. citizen and how that's kind of got us all kind of messed up because we don't know who we are. So we'll talk about what's the federal region and federal zones. That's another way they get you. Using zip codes and two-letter state designations, unconscionable contracts, and so on. Will probably take us about 3 sessions to get, maybe 2 sessions more, maybe 1 more session. Actually, I think we can get through this. And then in our premium member class, we're also going to get into some details about the bond, the birth certificate, how to set that up, how to create a proper Uniform Commercial Code filing that is actually a non-UCC filing, done in a way where it puts in a proper claim that you can come in using their system to claim all those assets that they've been creating based upon your name, because every time they open one of these courts, they're creating a ton of assets. I'll actually put a blog article up on this week, but then we'll cover that blog article in a discussion in a future call as well. So lots more to cover. If you're so please attend the next free call. We'll get into that, but also the premium members watch on the next call. I hope you took good notes tonight. I hope you all pick up that book, the UCC Connection, How to Free Yourself from Legal Tyranny. It will be a good guide for you to get your balance. And then we will do some Q&A on that. Premium members, just if you are on this call, we're about to start on a path of developing a new kind of status system, a simple, very quick, and efficient way to get your status recognized. A lot of people have missed the boat on this, made it too complicated. We're going to show you how to do it fairly quickly. But first you have to know, before you can do it, you have to have the foundation, both spiritually and legally, to understand it, because it won't work if you can't go in and have a conversation about it. If you can't back it up to that level comfortably, even if you're nervous, it won't work. Nothing will. No document in the world, no magic document in the world will work. Although there is a good affidavit of truth status document that's now in your documents folder for the premium members. Be sure you go check that out. Get your hands on that. It's in the documents folder, affidavit of truth. You might want to read that and start preparing that. For the rest of you, just stay tuned. And if you want to find out about the premium membership, it's all on the website. But really, I want to make sure we also give you just a ton of great information here on the free side as well. If you have questions, feel free to email those in to support@urlaw.org. Like I said, on this call tonight, we're not really taking questions. The premium members, we will be having a call in a couple more days. Watch your email for that, where we will get into more in depth about some of the questions. As we go through this overview material, I don't want to do too many questions because we still haven't gotten through the material, and frankly, we'll probably cover most of your questions. But if we said something you were a little confused by, bring that to the premium member call, and we'll be glad to get into that when that happens. So now, just a quick announcement on a couple of other things. Those of you members who've heard about the foreclosure program or the mortgage trust recovery system, those are still ongoing. You can get some information on the premium page. Get in there and read about it if you're curious about how to do that. We also think that the new remedy system we've got coming will also help deal with those issues very, very effectively, and all of our premium members will be trained on how to do that. So if you're dealing with a mortgage or a past situation, or if you even had a mortgage a couple of years ago and you lost a house, there still may be funds to recover. Once you get your status lined up and you get your documents in order, you're going to find out it's going to be one of the simplest systems so far of what I've seen of it. And to be honest with you, parts of it are still being tested. So before we fully give you the details, we want to make sure it's more than just a beta test version of it. And that's underway now. There's actual cases underway right now. So we'll be able to give you some really good remedies. Everything that I've studied over the years, it's been 20-plus years, has led me to the conclusion where we're at. Where you're getting here is a consolidation of the stuff that makes sense, that can work for most people. Everybody has to make it work for themselves. There's no one script for everybody, so get off that. But I think this process we're getting into, especially when it comes to how to get your status recognized, how to get in, get your credits back that have been taken from you. Again, we'll get into more details on what that means soon, but it's there, and we're very excited to be able to present that for our members. So we're looking forward to working with all of you, and until the next call where we'll continue on and studying this booklet here and getting a good rounded subject on that. Be sure to download this. Please feel free to share the TalkShoe page or the free member page with people, and tell your friends about us. We're trying to get the word out, help people to wake up, but we can only do so much with it. The rest of it's going to be up to you. I appreciate you all being here tonight, and we'll see you all next time.